Hello, I'm John Feyen, a candidate to be your next Larimer County Sheriff. Our nation's founders put considerable thought and great personal risk into establishing our Constitution. As the beneficiaries of their wisdom and courage, it's our duty to uphold the rights established in their guiding document. This great country is founded on liberty and justice for all. As your sheriff and as a fellow American, I vow to uphold these sacred rights.
You just heard John Feyen say in that political ad that he cares about the Constitution and your rights. In the next clip, you're going to hear what he had to say during his campaign for the office of sheriff. You get to hear what he said in response to a question from an audience member.
We'll start out with you on this one. Have you ever been sued in your official capacity as a law enforcement officer for violating citizens' state or federal constitutional rights, or a tort claim such as excessive force or assault? And that's for both of you. Yeah?
No.
Rob?
Yes.
Would you like to expand?
Oh, okay. Well, that wasn't part of the question. Yep, absolutely.
I added some more to it.
Oh, you added more to it? Okay, perfect. Yeah. Yep. Actually, I was sued by the same person twice for the same thing, and both times it was dismissed.
The Estes Park businessman who sued John Feyen in 2003-2004 for John Feyen's illegal actions that occurred, ironically, on December 13th of 2002, ironically because today is December 13th, Friday the 13th of 2024. So 22 years ago, John Feyen was sued because, well, I'll just read from the actual lawsuit. At that time, defendants Feyen and Holloway of the Larimer County Sheriff's Department identified themselves, and Mrs. Chalik opened the door, and those defendants, along with defendants Marciniak of the Estes Park Police Department, walked into the subject property. No big deal so far, right? Except for this part. Neither the Larimer County Sheriff's Department nor the Estes Park Police Department nor the three defendant officers had an arrest warrant. So Feyen and his friends from Estes Park and the sheriff's office just walked into the Chalik's house at 11 p.m. on December 13th and arrested Mr. Chalik. Immediately, Mr. Chalik was arrested, placed into custody, and dragged from the subject property, whereby he was taken by defendant Feyen to the bottom of the canyon on Highway 34, about 10 miles from Drake, where defendant Feyen was meeting another officer to take him to Fort Collins, Colorado for detention. That means to go to jail. During the transport of Mr. Chalik from the subject property to Fort Collins, Colorado for detention, defendant Feyen advised Mr. Chalik that he had voluminous documentation on Mr. Chalik that would put him away for several years. Also, during the transport, Deputy Feyen advised Mr. Chalik that they were going to take Mr. Chalik's computers from the subject property and that they would not be returning Mr. Chalik's computers back to him for about 2 weeks, despite the fact that Mr. Chalik advised him that it was his source of income for work. Upon information and belief, defendant Feyen requested defendant McGee's ex-husband to generate a false and negative report against Mr. Chalik in the town of Estes Park, Colorado. Upon information and belief, defendants Duvall and McGee have conspired, along with the other defendants, against Mr. and Mr. Chalik, as more fully set forth below, including to engage in an intentional and unlawful arrest of Mr. Chalik, an intentional and unlawful search of plaintiff's subject property, and the commencement of a malicious, discriminatory, and retaliatory criminal prosecution against Mr. Chalik. The intentional and unlawful arrest and detention, the intentional and unlawful search in violation of plaintiff's right to privacy, and the malicious discrimination and retaliatory commencement of prosecution of Mr. Chalik by defendants or others was done when the defendant officers had no lawful authority to arrest Mr. Chalik, and their actions were done with actual malice toward Mr. Chalik, and with willful and wanton indifference to and deliberate disregard to the statutory civil rights of Mr. Chalik. As a result of the conspiratorial actions of the defendants, Mr. and Mrs. Chalik had to leave the state of Colorado. So, Chalik sued Feyen in 2004 for violations of his 4th and 14th Amendments, civil conspiracy, invasion of privacy, intrusion into seclusion, intentional infliction of emotional distress, false arrest and false imprisonment, abusive process, malicious prosecution, and aiding and abetting tortious acts. So as part of Chalik's lawsuit, Deputy District Attorney Andrew Lewis filed a sworn affidavit about the case, and what he said was shocking. First of all, that he admitted it, that the DA admitted it, and second of all, that he put it in a sworn affidavit. But basically it says, during the course of this case, the defense, Mr. Chalik, provided me with evidence they would use to impeach certain important witnesses for the state. Now, one of those certain important witnesses for the state was defendant John Feyen. So when Mr. Chalik is going to prove that he can impeach John Feyen, what that means is, in plain English, is that Mr. Chalik can prove that John Feyen was lying as a part of his official capacity while on duty with the Larimer County Sheriff's Office. All right, so specifically, it was specifically reported that Michael Chalik had followed Mrs. Duvall on February 19th, 2003 at around noon in Estes Park, Colorado. In June of 2003, now remember, this is the Deputy District Attorney Andrew Lewis swearing under oath that what he's saying right here is true. In June of 2003, the defense, claiming these individuals were lying about Michael Chalik, provided me a videotape recording from a bank in Florida to prove that Michael Chalik was in Florida on this date and time. So that means that John Feyen, well, you know what that means, John Feyen did. All right, so remember, Feyen answered the question in the public candidates forum saying he had been sued by the same person twice. Now you know that's a lie. And John Feyen knew it was a lie when he said it, but he said it anyway, and that's part of the actual malice piece. If a person is lying and they defame you while they're lying and they know they're lying, that's actual malice. John Feyen and Justin Smith left a lot of evidence of their actual malice in the 2 defamation cases against them, and we'll get to that. All right, so John Feyen, you saw his campaign video where he promises to care about the Constitution and your rights. And then at the candidates forum, he lies about the lawsuits against him for violating the Constitution and violating individual rights. So two different people sued John Feyen 15 years apart for constitutional violations. It was not the same person twice for the same thing. In my lawsuit against John Feyen, remember, John Feyen's answer was some convoluted, twisted, distorted lies about the 2 lawsuits I supposedly had filed against him. In fact, the one lawsuit I had filed against him was fresh on his mind because it wasn't that long before it had been dismissed by the federal district court. But why it was dismissed is critical, and Feyen left out that part about why it was dismissed. So in my lawsuit, I sued him not for the GPS tracking device attachment, which was illegal. We all know that was illegal. I didn't sue him for the illegal cell tap that he put on my cell phone and lied to T-Mobile about. That's not why I sued him. I sued him in federal district court because, oh dear God, John Feyen and Justin Smith and David Arode hid the records of John Feyen's illegal attachment of the GPS tracking device to my SUV. That's why he was sued, because he hid the records for 8 years. That's called a conspiracy. Ironies of all ironies. Justin Smith, David Arode, and John Feyen engaged in a blatant, provable conspiracy to keep me from knowing what happened with the illegal attachment of the GPS tracking device. So I sued him for that conspiracy and blocking my access to my right to sue him. He did that by hiding the records well past the statute of limitations. So the case against John Feyen in federal district court that was filed by me was dismissed because after 8 years of them hiding the records, the statute of limitations had expired. So I was not able to sue them. Go figure. And I'll post these actual screen grabs on the screen so you can read them if you're interested in the specifics of things about like investigator Troy Miller, investigator Josh Sheldon, Feyen, how they actually got away with it by hiding the records, how they hid the records. That'll all be on the screen. On December 21, 2011, a GPS tracker was surreptitiously placed underneath a 2002 black Ford Expedition registered to Stacy Lynn. Now again, I'm reading straight from the federal lawsuit against John Feyen. There was no warrant which authorized its installation and no exigent circumstances which authorized this warrantless installation. The GPS tracker was installed on the vehicle of Stacy Lynn by investigator Troy Miller and investigator Josh Sheldon, then employees of Larimer County Sheriff's Department. Investigator Troy Miller and investigator Josh Sheldon were instructed to do so by defendant John Feyen, then employed by Larimer County Sheriff's Department. The identity of investigator Troy Miller and investigator Josh Sheldon, as well as the fact that they were directed by defendant John Feyen, was not disclosed to plaintiff until October 30th of 2019. Now remember, Feyen placed the tracker on my vehicle on December 21st of 2011, and they hid the records until October 30th of 2019. Again, reading from the federal lawsuit against John Feyen. Now, this is the second federal lawsuit against John Feyen by the second person, not, as John Feyen said, that he was sued by the same person twice for the same things. On or about May 5th, 2012, as Stacy Lynn was using the jogging track at CSU, she became aware that she was being followed by someone on a motorcycle. She called the Fort Collins police to report it and was informed that she was being followed by a CSU police officer. When Stacy Lynn returned to where her car was parked, she observed that there were several Fort Collins police officers surrounding it. The officers dispersed as she approached. Stacy Lynn looked underneath her car and discovered a large electronic tracking device attached to the inside of the rear bumper. Defendant John Feyen engaged in a pattern of actions which were violative of the clearly established Fourth Amendment rights of plaintiff Stacy Lynn. He accessed her cellular telephone line without a court order or exigent circumstances, interrupting an ongoing conversation. He arrested her without a warrant, exigent circumstances, or probable cause. Who does that sound like? Oh, that sounds like what John Feyen did to Michael Chalik. Defendants John Feyen, investigator Troy Miller, and investigator Josh Sheldon, as Stacy Lynn now knows, installed a GPS tracker on the automobile without a warrant or other legal process which authorized that installation. The installation of the GPS tracker was done at the direction of, or with the knowledge and approval of, and or subsequent ratification by Justin Smith. He may be deemed to be a policymaker for the issue of the GPS installation on the vehicle of Stacy Lynn. The conduct of defendants Justin Smith, John Feyen, investigator Troy Miller, investigator Josh Sheldon was a violation of the clearly established federal constitutional rights of Stacy Lynn. Now remember, you just heard John Feyen when he was trying to get elected as your sheriff. You heard John Feyen say that he cares about the Constitution and he cares about your constitutional rights. Well, he said that at the same time he was lying and deceiving the voters, because if he would have told the truth, we would not have John Feyen for a sheriff. It would be clear who our sheriff would be, and he would be an honorable, law-abiding, clean sheriff. That is not who John Feyen is. Continuing from the federal lawsuit. As described here and above, Sheriff Justin Smith and County Attorney David A. Rote were aware of documents which describe the circumstances around the installation of the GPS tracker upon the vehicle of Stacy Lynn. Without limitation, but by way of example, we now know that Brad Harkin, in the Professional Standards Unit of the Larimer County Sheriff's Office, sent an email to John Feyen advising him that County Attorney David A. Rote spoke to him regarding the GPS unit that was on Stacy Lynn's vehicle. Now, this all happened after I discovered the tracker on my car. All of this part. David A. Rote advised Brad Harkin to, quote, keep it, the GPS tracker, in evidence for at least 2 years past the date of the incident, and an additional 6 months for good measure, and to assure all statutes of limitations have expired. Remember, they hid those records for 8 years, well beyond the statute of limitations had expired. That is called a conspiracy to prevent me access to the courts so that I could sue them for their illegal actions. By their actions in concealing documents concerning the installation of the GPS tracker on plaintiff's vehicle, including but not limited to the identity of the person who installed it, defendants Justin Smith, David A. Rote, and then the commissioners, Donnelly, Johnson, and Kafalis, conspired to keep Stacy Lynn uninformed as to the factual basis for a civil lawsuit, and thus deprived plaintiff Stacy Lynn of her right to access the courts, a right and privilege of citizens of the United States, in violation of 42 U.S.C. 1985. Now, this is our sheriff that we're talking about. By their installation of the GPS tracker on the automobile of Stacy Lynn without a warrant or legal process authorizing such an installation, Feyen, Miller, Sheldon, Smith intentionally invaded the privacy of Stacy Lynn. That invasion would be very offensive to a reasonable person. That invasion caused plaintiff Stacy Lynn to suffer injuries and losses. Now, what happened was, it was on my SUV for at least 4 months. And when John Feyen testified at his deposition as part of the defamation per se actual malice lawsuit, Feyen indicated that that tracker may have been on my vehicle for possibly an additional year. I do not know if it was 4 months or a year or however many years. I don't know about that because they're still hiding records related to this case. If John Feyen would have answered the question honestly, remember all the way back to the beginning where the host of that public candidates forum asked both Jeff Fisher and John Feyen the question, have you ever been sued in your official capacity? If Feyen would have answered the question honestly, this is what he would have said about the Estes Park businessman's lawsuit. I was sued by an Estes Park businessman in 2003 because I arrested him, accused him of committing a crime that was physically impossible for him to commit. The district attorney charged him with a crime, but then the district attorney swore under oath that the innocent man could prove that John Feyen's investigation was a gross fabrication. That's what John Feyen should have told the voters and the public about the first federal lawsuit against him. I bet you can figure out why John Feyen didn't tell the voters the truth. Okay, if John Feyen would have answered the question honestly about the GPS tracker records conspiracy case, this is what he said. This is what he should have said to the voters to tell them the truth about who he actually is. I lied to T-Mobile to get an illegal cell tap on Stacy Lynn's phone. I deceived superior officers when I put an actively tracking GPS tracker on Stacy Lynn's car without a warrant. I left the GPS tracker on her car for more than 4 months without a warrant. I hid the records about the GPS tracker from Stacy and her attorneys for 8 years. That's what he should have told the voters if he was being honest. A clean cop, first of all, would never have done what John Feyen did to Michael Chalik or to me. But if he had any bit of remorse or any bit of decency left in him, he would have told the voters what he did to Michael Chalik and what he did to me. But he didn't. Not only did he not tell the voters what he did to me, he maliciously defamed me, lied about his own criminal actions in the GPS tracker case, and he did that all to get elected. John Feyen lied about being sued by the same person twice for the same things because he is covering up. He is trying to cover up. He has been covering up decades of his own illegal actions. In the next video, we'll summarize what John Feyen testified under oath in his deposition, specifically as it relates to his twisted lies to the public, to the voters about being sued by the same person twice for the same things. We will go through his deposition and talk about how he tried to explain away the lies.
Yep. Actually, I was sued by the same person twice for the same thing, and both times it was dismissed.